Welcome to Prosecuting Employment Tax Fraud and Alien Harboring Together, HSI and IRS Joint Forces. I'm Philip Behrendt, Chair of the BHBA Tax Law Section. The Tax Law Section is sponsored by Hochman, Salkin, Toscher, Perez, PC. The Hochman, Salkin, Toscher, Perez, PC advantage is experience, an eye for innovation, and a genuine dedication to clients, their families, and their business, in addition to their national practice in civil and criminal tax controversies and related litigation in federal and state courts. The firm is also active and successful in handling white-collar defense. Today, I'm delighted to introduce our speakers, Professor Jean Reisz and Evan Davis. Professor Reisz teaches at and co-directs the USC Gold School of Law Immigration Clinic and teaches the Immigration Detention and Appellate Clinic and the Legal Profession courses. As co-director of the Immigration Clinic, Professor Reisz oversees the Immigrant Legal Assistance Center, which provides free legal assistance to USC students, faculty, staff, and their family in connection with immigration-related issues. Professor Reisz was a trial attorney for 6 years at the Los Angeles County Public Defender and alternate public defender, handling misdemeanor and felony cases in downtown Los Angeles and Compton. Prior to joining USC Gold, Professor Reisz was a senior associate at Archer Norris plc. Evan Davis is principal at Hochman, Salkin, Toscher, Perez. Before joining the firm in 2016, Evan spent nearly 20 years with the U.S. Department of Justice. He was first a civil trial attorney with DOJ's tax division, then an assistant U.S. attorney in the CD, California's tax division, handling civil and criminal tax cases, and finally a criminal AUSA and the USAO's major fraud section, handling white-collar tax and other fraud cases through jury trial and appeal. He serves as a bankruptcy fraud coordinator, financial institution fraud coordinator, and securities fraud coordinator. And now, with all of that, let's get started.
Well, thank you very much, Philip. And thank you, Professor, for joining me for this presentation. We probably have a group of listeners who are a combination of immigration attorneys and tax attorneys. We're going to try to give you information that's applicable to both. This is definitely feeling like a new era for tax lawyers. We'll see what happens with the IRS in the coming days, but the tax division and the Justice Department, for example, has been disbanded, and the attorneys have been spread out between the civil and criminal divisions of the Justice Department. There have been big changes at the IRS, including based on personnel. But one area that has not lost that many folks is IRS Criminal Investigation, and they definitely continue to be busy. And one of the areas that they're busy is the focus of today's presentation, which is on how the IRS and Homeland Security have joined forces, which is not actually a new thing, as we will talk about. But first, I would like to turn to the professor and have her talk about some of the changes that we've seen that might be interesting and relevant to the presentation today when it comes to immigration law.
Well, thank you for including me in this presentation. And, I thought maybe I would just start off with presenting a little bit about the climate that we're working in, this kind of new aggressive enforcement climate. I would say generally now is not the time to try pushing the envelope when it comes to immigration laws, obviously, and employers who are related to that. We have several kind of new executive actions that have really targeted, that have prioritized immigration enforcement, that have shifted resources, that have shifted policy, reinterpreted statutes. I mean, an extreme example is reinterpreting the 14th Amendment of the Constitution, right, as an enforcement, the birthright citizenship. So we've got this really kind of enforcement-oriented agencies. We also have what we call force multipliers. So as you know, Evan pointed out, the cooperation between IRS and Homeland Security's investigation isn't anything new, but we have IRS agents that are actually being deputized to enforce immigration law. And we've had resources shifted, for example, from firearms, tobacco, and alcohol to immigration enforcement. So we also have state governments that are local law enforcement being deputized to engage in immigration enforcement. So we call them force multipliers because it really increases the ability of enforcement beyond the Department of Homeland Security. We still have, the kind of I-9 audits, focuses on workplaces, but we're seeing kind of bigger raids, so to speak, bigger enforcement operations, and I'll talk a little bit about the Hyundai mega plant in Georgia. There's policy shifts. I mentioned one of them is the U.S. Attorney Pam Bondi in February of 2025 issued a memo saying we're prioritizing immigration-related crime and criminally charging companies. And we may see a shift. I will say we haven't really seen it yet, this kind of increased attacks on employers, but the memo talks about this shift from maybe punishing with fines to more draconian punishments for immigration-related offenses, criminal offenses. And then we have kind of unprecedented cooperation between Department of Homeland Security and IRS when it comes to sharing private taxpayer information, people who have, their ITN numbers and using that information for people who are reporting and paying taxes to try and locate their places of residence as a result of enforcement law. Many people who aren't eligible for Social Securities and who are undocumented may still be paying their taxes under their ITNs. So that is kind of a big enforcement. And then I would say too, we're going to see the use of AI to look at employment records, to detect tax crimes and harboring. We'll see, overall increased scrutiny by the government. And then another kind of part that I'll talk about a little bit is how we're seeing the termination of lawful statuses, which affects people's ability to work, which affects employers, compliance with the law. And I'll talk more about that. So just, we're in a situation where it's kind of all hands on deck with immigration enforcement, and that's going to draw more scrutiny on employers as well. Oh, and
yeah. Go ahead.
This is just a slide to give you an idea of how many, people, are having these, tax filings and undocumented tax filers. And so, the sharing of information between the IRS and DHS is really going to be used as a tool to go after people's information to find where they are if they're undocumented.
Well, and I know that you talked about ITINs. The idea behind, for those who are not familiar with it, the idea behind an ITIN is you do have people working in the United States who may not be allowed to work here or don't have a Social Security number, for example. And basically the government wanted a system by which folks like that who are earning money, whether they're allowed to or not, are reporting it and paying tax on it. So they came up with this ITIN, the individual tax identification number, and the whole idea was to increase compliance for the people who are operating perhaps in the shadows and perhaps in anticipation of a later test when the government decides who can become a US citizen. One of the tests was, were you paying taxes all along? So the ITIN was set up for that reason. Professor, we didn't talk about this before, but it just is kind of a natural question based on what you said earlier. Is that going to come back to bite people? Is that something that that lawyers are going to be hearing? Should should I be worrying about my employees reporting ITIN information, because is that just going to be shipped over to Homeland Security and ICE, and that's just a much easier way of finding people who are not here lawfully?
Yeah, I think it really kind of it has this negative policy implication of decentivizing people from complying or paying taxes under the ITIN, because that information can be used to remove them, to locate and remove them from the country. And I think that those individuals are in a rock and a hard place, because, as you point out, when it comes to certain immigration applications for status, one of the things that are looked at is good moral character. And one of those things that are looked at are, did you pay your taxes when you were supposed to? And so that would be something that would be a good thing. But now I think people are really hesitating about whether they should give their information and do that, because it's going to be used to track them down. And I think, just with the background of what you see on the news with the aggressive enforcement, I think people are scared too.
Well, so let's move to the tax side of things first, and then we'll talk about some of the immigration crimes that can come into play. What statutes are at issue in the cases that we're expecting, right? The professor indicated we haven't really seen an increase. We are going to actually talk about some very recent cases from 2025, as well as some historical cases in a bit. But what statutes can be brought to bear to address at least the tax side of these immigration and tax cases? And setting the table, I mean, the standard situation in which you will see a nexus between a tax crime and an immigration crime primarily is in an employment situation. It's not generally the standard individual income tax return situation, although you could see that coming to bear just if someone had overstayed a visa, had been deported at some point previously, is coming back into the country. You might get an illegal reentry charge. But really, this presentation is more about what lawyers who are either advising businesses or lawyers who have a business person who comes into them and they're either under investigation, have been charged. So what are the statutes on the criminal tax side that we're looking at? Well, the first statute, which is one that even criminal tax lawyers don't run across that much, is 26, that's the tax code, US Code, Section 7202, which is the willful failure to collect or pay over tax. This is a common employment tax charge, although employment tax charges have waxed and waned over the years. I remember when I was in AUSA, we started doing more of them, and then it seemed like we were doing less of them. And during my last 9 years, when I've been in private practice, it seems like this became a focus, doing criminal employment tax cases. Section 7202, in essence, is the criminal analog of the civil penalty case against employers who who collect but fail to pay over tax. So often these employers are collecting tax from employees some of whom in this situation may not be here lawfully or may not lawfully be permitted to work, but they don't then send the money over to the government, for example, or they intentionally fail to collect tax, which might be a more common situation in the immigration context, where they may be paying employees without taking any money. So there is a statute available for that, which is 7202. 7201 is the standard tax evasion case, and it is quite a broad section. it can basically encompass a one-person conspiracy, if you want to call it that, where an individual, in this case, it could be an employer, evades either the assessment or the payment of tax. In this situation, it's most likely that the IRS would be looking to investigate evasion of assessment. And it wouldn't necessarily be the assessment of income tax, although that could be part of it. It would be the evasion of employment tax. But if you think about it, if you're not reporting the wages to begin with, you're obviously not going to be paying or reporting employment tax obligations, but you're also causing, in essence, the employee not to report or feel like they don't have to report their income. And there can be an income tax angle to it as well. Keep in mind, tax evasion doesn't just include evading your own income tax. If you are assisting someone else to evade their income tax, then this statute also can apply. You also have a willful failure to file, return, supply information, or pay tax, which is a misdemeanor. This is available as well. I've already described the 7202 situation. So this is in case you are negotiating with a prosecutor, generally you start out by saying, this case should be a civil case, so I don't know why you guys are prosecuting my poor client. And then you move to, well, at very least it's a misdemeanor. So just keep in mind that there are misdemeanors available. The tax division of the Justice Department, when it existed, generally did not like misdemeanors. Who knows whether that's going to change under a new administration when you have people whose life does not revolve around tax, supervising folks who are primarily doing tax work. It remains to be seen whether you're going to have the same ethos when it comes to protecting the tax code and protecting the taxpayers when you have diffused the tax division into civil and criminal divisions. But as of now, at least, the tax division's not been too happy with misdemeanors. So 72061 and 72062 are the false tax returns and false statements charges. 72061 is just filing a false tax return for yourself. That could be a false employment tax return or individual income tax return. But there's also the aiding or assisting. And this can come into play in a situation where you have an employer and an employee who is off the books or not fully on the books, for example. And all you need to do for 72062, in addition to obviously having the requisite intent, is to basically create some sort of a document. And it doesn't have to be an official document. It could be pretty much any document that aids or assists another person in the preparation or presentation of a false document. You also have 7207, another misdemeanor, which is basically a false return or other document. This is really, again, more of a negotiating tactic. You don't see the government charging this that often on its own. It's really more in a resolution context. And then you have a very broad statute, which is section 7212, which is a catch-all. And in fact, courts have expressed some concern about how broad this statute is. In essence, anything that is done that makes the IRS's job harder could be considered a 7212 count. So you could see how that would come up in terms of paying employees under the table. It also can come up in a situation of an audit, which is something that we will talk about at some point today as well. When you're representing an employer you need to make sure that the employer doesn't make the situation worse in the audit by providing false information. And this is a count that, in the context of an audit, the IRS loves to investigate and the Department of Justice loves to bring. So now, what about on the immigration crime side? What criminal statutes are we looking at, and what do the penalties look like?
So, what I'll be talking about mostly today is this concept of harboring, because it's so broad. There was, and I'll just kind of as an aside, there's no legal definition for harboring. So the courts have been tasked with interpreting what that means, and circuits don't completely agree. I'll be talking more about employment and some of the other kind of sheltering aspects of harboring. But I did want to mention that there was a Supreme Court ruling in 2024 in State versus Hansen that challenged this statute, this idea of bringing or attempting to bring, and then an aiding and abetting, kind of like facilitating that person to come unlawfully. And it was challenged on a First Amendment basis that the statute was too broad. And the Supreme Court, in a 7-2 decision authored by Justice Coney Barrett, said that, we're talking about the criminal use of the words and not the kind of colloquial use that would be broad. So I open with that example because that's really the most recent kind of challenges to this statute that we've seen, and it's been on a First Amendment basis for the language. So there is a lot of criticism in the immigration scholarship about how this statute is so broad and isn't clear, and courts are left to interpret, and that Congress really should be considering revisions. So regarding kind of, well, then what is harboring? The short answer is that employing somebody who is unauthorized to work without more is not going to lead to harboring charges. Most of the harboring cases require some kind of act to avoid detection. And so, for example, in one of the cases, an employer who was an agency that had employed people to do custodial work had provided false identifications for background checks to clean government buildings. So that was really, there were harboring charges that were successfully pressed in that case, because that required also like trying to avoid detection by providing these false documents. Okay, so the basic elements of the harboring is that there is knowledge that there is an immigrant who is present in violation of immigration law, so either entered or remained in violation of law. And then the defendant in this case would conceal, harbor, or shelter the immigrant in the United States. Again, it's very broad language. And then that person also has to take some additional action to substantially facilitate somebody being in the US in violation of the law. So in the Ninth Circuit, which is where we are, generally harboring could be sheltering individuals, but it gets a little bit thornier regarding whether or not harboring is a specific intent crime. And in the Ninth Circuit, they've held that so sheltering and knowingly sheltering an undocumented individual could fall under the harboring statute, but there has to be this intent, a specific intent to kind of further that presence in violation of immigration law. So we still have, if, for example, renting an apartment to someone who is undocumented would not fall under harboring. So I'm going to, maybe give examples of cases where there has been found not to be harboring. And many of these cases involve some sort of attempt by the defendant to evade federal agents, or sheltering individuals and transporting individuals as part of their employment. So an example of harboring, there was a case where a restaurant owner required federal agents to obtain a warrant before coming into the restaurant. And while the enforcement agents were getting the warrant, the owner of the restaurant facilitated the undocumented workers there to leave as to pretend that they were customers to leave undetected, and then transported them to another location. So it was that dual thing, you know, just exercising your rights and requesting a warrant. This is an older case. You know, that wouldn't be harboring, but then that additional action of, you know, really intentionally attempting to obstruct the federal agents from enforcing immigration law. Another example was, you know, an employer at a scrap metal yard who was also lodging workers at a warehouse and transporting them back and forth and advising them how to avoid detection. Also not reporting tax, you know, engaging in the kind of tax offenses that Evan Davis had just described. In the Ninth Circuit, there's a fairly broad interpretation. So like I said, just sheltering could be fall within the harboring statute. But because it's a specific intent crime, most cases have required that there's something about wanting to facilitate that unlawful presence as part of that sheltering. Another major element of the harboring cases is the knowledge or reckless disregard of the fact that the person's unauthorized. Many defenses to kind of the unlawful employment statutes in immigration by the employers is, well, I didn't know. I was asked for the information to, you know, the employment records, and I didn't know that they did not belong to that person or that they weren't part. So that has been kind of a design of our employment authorization program since it was established under Reagan in the, you know, IRCA, the Immigration Reform Accountability Act. And so there is and some of, you know, many of you might know the E-Verify system, which the information that the employer enters about their employee is then compared to records in the Department of Homeland Security and the IRS. That is not a nationwide mandated system. Some states, I think about 22 states now, require employers to use E-Verify. California is not one of them, but federal contractors have to use it. Institutions that accept federal funds, for example, many universities have to use E-Verify if they're accepting federal funds. So that's one way that there's this kind of additional verification step, but it's not required, you know, by the statute. So knowledge or reckless disregard, if you should have known, if the circumstantial evidence would have shown that. And then the other element is whether or not that defendant, for the, you know, individual, acted for commercial advantage or private financial gain. And this really doesn't require the government prove that you have exchanged or received something of value, received money or something of value. It just has to be for this commercial advantage. So it's a lot more broad. If that is the case, then the maximum penalties are fines, right? Or up to 5 years for each unauthorized immigrant that is being harbored under, you know, is prosecuted. Sorry, it's 10 years. If there's no commercial advantage, it's 5 years. So it's a 10-year maximum. And then there's other kind of increased penalties if the harboring resulted in great bodily injury or jeopardized the life of an individual, then that's up to 20 years. So historically, I think there's been a lot of fines, except for really egregious cases where there has been a link to workplace violations. You know, a lot of these kinds of prosecutions are resulting from investigations into complaints or workplace violations. And then from there, these harboring charges are usually brought. Let's see, what else can I say? Okay, so I guess maybe I'll stop there and we can talk about some current cases.
Let's do it.
Okay.
Well, why don't I start with an old case, which is one of the reasons why I'm doing the presentation, because this was my case, along with a handful of other prosecutors. Interestingly, the defense included my current law firm, so it all kind of went full circle in that regard. But this was a case involving a gentleman named George Torres, who was charged with RICO murder, with honest services, fraud, basically public corruption, tax crimes, which included failing to pay employment tax, and as well as harboring, which the professor was just describing. And it was basically 4 cases in one, but it's a pretty rare case. I mean, I and the professor were looking for examples dating back basically as far as we could, just looking for press releases and similar things to try to find out how many of these things came up. And at least in the Central District of California, there are very few examples, and even nationwide, when we did that search as well, there are very few examples of cases involving criminal charges for harboring that also included the, in this case, Section 7202, the willful failure to collect taxes that I mentioned before. This case involved, as I mentioned, RICO murder, the allegations that the jury found and later dismissed involved, in essence, killing some people who made threats or killed people who worked at his grocery stores. But the aspects of the case that are relevant to today involved paying known workers who were here illegally under the table, and at the same time providing housing for them, which is something that the professor mentioned earlier about, well, if you're just a landlord providing housing to someone who you know is not supposed to be here, that's not going to get charged. But in the instance of an employer who is paying someone under the table and at the same time finding a location for all of those workers to live, that was the focus of the employment tax and immigration aspects of the case. So that got me, I guess, interested in the area. And I remember doing a presentation a few years later about how these cases can work and how easy it is to prosecute. But notwithstanding that the IRS was talking about doing the cases, I really didn't see any more in the additional, let's see, 2000, I think this was 2009. So the additional 7 years that I worked for the office, I don't think I saw more of them. As I said, as easy as they were, there are task forces that you have Homeland Security and the IRS on. This goes back a lot of years, but their focus usually is on organized crime and drug cases, not cases like this. Well, the Torres case was an example. This came out of a task force that involved local as well as federal agents. And there was, as I described, this kind of gang and violence aspect to it. So in essence, the tax and the immigration charges were really just along for the ride with the more serious charges. But that's just not terribly common. So cases really weren't coming up that often. But we see examples, and Professor, I forget which ones you're going to be talking about, but we found an example in 2011 in Pittsburgh where there was an alien harboring money laundering case. So a couple years after the one that I prosecuted here in LA. By the way, all of the full press releases and the indictment for Torres is in the materials. And it was a kind of a standard case in Pittsburgh where you see hospitality industry workers being paid under the table, harboring for commercial gain, money laundering, et cetera. So they're kind of few and far between until 2022 and the Biden administration. And I don't know whether it was President Biden, whether it was the Attorney General, whether it was the commissioner of the IRS or someone else, but it seems like starting in 2022, the IRS got interested in these cases again involving harboring as well as employment tax. And Professor, what are your thoughts? I mean, I know politically what people have said about the last administration and immigration, but at least if you look at the volume of cases involving tax as well as harboring charges, it seems like the upswing started during the last administration.
Yeah, I would agree with you. I think that that our former President Biden's position on immigration being open borders policy is exaggerated on one side. That there was aggressive enforcement under that administration as well. Maybe not to the degree that we're seeing currently, but definitely carrying into the Biden administration from the first Trump administration, a lot of policies and kind of focus on the issue of unlawful immigration. I mean, one thing is these kinds of statutes, I think, are going to be used more to make examples of people and to kind of overall deter unlawful immigration for economic purposes, so that employers and employees will be facing harsher consequences. I think that's kind of part of the increased attention here, which I think was part of Biden's administration as well.
And we'll just scroll through. We have October 2024, December 2024, another case. March 2025 is Morgantown, West Virginia case. Now, those of us who do these cases, and I know the professor used to be a defense counsel, it's very difficult to put together a federal tax and immigration case within 2 months. This is 2 months after the inauguration. So this is very likely a case that had been going on for a year or more. I mean, my experience with the IRS is 2-3 years is not uncommon from start of a criminal investigation to charges. But it would be light speed if this was actually started under the new administration. So this is really an indicator of something that happened beforehand. And Professor, I know you wanted to talk about the Charleroi staffing case too.
I would say that with this, we have this kind of Operation Take Back America was the name of the operation. And I think that this is one of the cases under that operation. So I don't think it was just for the Charleroi case, or Charleroi, I guess, or my French accent is struggling.
Yeah.
But, this is a case where it wasn't just not reporting, employing unauthorized immigrants and not, in this case, it was a staffing agency that wasn't reporting about, I think only 10% of the business were people who were able to work. And so there were tax crimes being committed in not reporting all of the employees that were working there with the housing and transporting. And so you had immigrants who were being housed at a hotel by the agency and transported to their workplaces, in addition to the agency not reporting those unauthorized immigrants for tax purposes. And so in that case, there was a sentence that did include imprisonment. It was 30 months of imprisonment, as well as I looked up, I think that it was like, over $3.5 million in fines as well. But that, in that case, I can't, oh yeah, so that was over the summer in 2025. I don't know if you have anything to add to that.
I don't think so, other than it's possible there are a handful of cases that we never heard about, because the IRS tends to issue press releases when they receive a sentence that they're proud of. But that having been said, I would expect the cases that they're bringing in this area to receive substantial prison sentences, because you have the overlay of immigration. And I think the professor, what she does in her day job when she's not helping us out, is it seems to be much more focused on the workers in the situation than the employers. So often, I suspect you're seeing that the workers are very poorly treated, because if they're basically probably stuck in a hotel, they're probably told they can't go anywhere, and they're just shuttled back and forth, almost like prisoners. So that's the sort of thing, as a judge, that the judge would be concerned about. Now, some of the cases that we've handled recently that involve employment tax that arguably could have included a harboring charge if the right agency had been added to the case. Those employers treated their workers just fine. So it wasn't something that necessarily a court would have been concerned about. But when you hear, in addition to breaking the law, you're also abusing workers, that's the sort of thing that can generate some longer sentences. And I think here's another couple of slides that I think you added about the Chinese money laundering, and then we'll talk about the Iowa raid.
Yeah, I mean, I think this is just another example of, targeted kind of cooperative investigation. And maybe to highlight the difference between a trafficking offense and a harboring offense, because harboring covers a lot more than trafficking. But, there is kind of some overlap in certain cases. One of the related to some of these aspects are undocumented workers who are victims of trafficking. That could be a way for them to obtain legal status in the US. And so sometimes there's this overlap between the poor treatment and between possibly getting legal status, which is just something to keep in mind. And that's if they cooperate with an investigation, and that's if they help with a prosecution. So sometimes these cases get to the attention of the authorities because they are based on complaints by the employees themselves, even though the employees are undocumented and not working with authorization. I wanted to talk about this case because this was a big raid in 2008 on a meatpacking. There's a lot of focus on meatpacking raids. That there was, it was kind of this really organized immigration enforcement and employment enforcement. And I think about 389 workers, which composed, I want to say, half, if not more than half, of the post-Ville population. And they were unauthorized workers that were arrested. And the investigation started with complaints against workplace practices by the CEO. The CEO was not charged with harboring. The CEO was eventually convicted on a bank fraud and I think some other workplace violation crimes, but not harboring. But what happened in this case that is interesting is outside on a field, they had set up a judge, a criminal judge, immigration judge, and so they had public defenders, they had prosecutors on a field, and they were offering these kind of en masse pleas. So they were charging people with providing false documentation or identity theft related charges as criminal misdemeanors, and saying, we'll give you time, time served. We won't require any sort of imprisonment, but you have to accept deportation as part of your plea. And so it was really, I think that this is a model that might be used again, but where you're looking at kind of this intersection between enforcement and enforcement and workplace issues with hiring people who are undocumented. In this case, there were no harboring charges, but I wanted to point it out at this kind of concerted effort where you have federal and local judges and prosecutors, working together to secure a plea that affects immigration enforcement.
Thank you. So, if you're like us, or at least our firm, we're sometimes called on in advance to advise employers. Frequently, though, we're kind of the cleanup crew where something has happened and we're dealing with it in an audit or once charges have already been brought. But to the extent that employers are going to come in and say, look, I'm running a contracting business, and I do employ a number of people who are undocumented here. What should I do? And I mean, my immediate reaction is, well, I'm a lawyer. I've got to tell you to comply with the law. One of the things that I would tell employers is, I know that you're concerned that you will no longer be viable. You'll no longer be competitive. We've had a number of clients who've unfortunately been prosecuted for employment tax crimes, and they've cleaned everything up. They've gone back into business and they remain competitive. So you do want to give your clients some light when you're telling them, no, you got to get everything straight. But I know you were talking about E-Verify earlier. What sort of things should employers be looking to do to comply with the law if they're concerned that the jig might be up and they want to come clean?
I mean, I think, I agree with you. You've just got to comply. E-Verify, there's, that is a way to make sure someone stays in status. So one of the things that we're seeing is, for example, if you are familiar with TPS, temporary protected status, this administration has terminated or not renewed a lot of temporary protected statuses that people have. I think that there's approximately, I have it here in my notes, something that, tens of thousands of people who had lawful status and the ability to work that no longer have it because their designation has ended. So Venezuelans, Haitians, there's been parole programs that were started by the Biden administration that were terminated by this administration. So someone may have obtained a Social Security number, may have been authorized to work, and their statuses may have been abruptly ended by this administration. And so employers may have a valid Social Security number that no longer authorizes that person to work. So that's one of the pitfalls. DACA is another, that could end, and that would result in, about 400,000 people who were authorized to work to not be able to work. So that's one thing that's going to complicate compliance, is just staying up with all of the different lawful statuses that authorize people to work that have been abruptly ended, and those people are no longer authorized. And now you're in a situation where you're not complying today when you were complying yesterday. E-Verify seeks to help with that. But I think that, that comes down to best practices, and maybe, you, Evan, would be able to speak to that better than I would.
Yeah, well, I'd like to turn for the last 10 minutes or so to the nuts and bolts of what it's like to deal with this on the civil and criminal side. Those of us on the tax side, at least, are most likely to face this in a civil audit. And you might think, well, what does that have to do with Homeland Security? Keep in mind the past administration, the past IRS commissioner. I shouldn't say the last IRS commissioner or 2 commissioners ago, because of course we went through a half dozen or 7 or whatever the number is this year. But when Chuck Rettig was the commissioner, he emphasized having more cases sent from the civil side to the criminal side of the IRS, and that included employment tax cases. And that may be one of the reasons why, because he was commissioner between 2018 and I think 2022, that may be one of the reasons why we saw the increase in cases involving both Homeland Security charges as well as tax charges in the latter part of that period, 2022, 23, 24, et cetera. Danny Werfel was the commissioner after that. I have no reason to think that he shut down that program. So that the folks that are working at the IRS have been trained, if they're on the civil side, to be on the lookout for good cases. So one thing that we've seen repeatedly that could mean an error in a civil case, civil audit, is to try to hoodwink the auditor or distract them, not provide information, because I don't want to say it always happens, but what can happen is they'll figure it out on their own. One of the things the IRS has done recently is go after a lot of check cashers, both civilly and criminally. And they squeeze the check cashers to get information about, okay, who's coming in and cashing a lot of checks. If you're a contractor cashing a lot of checks, that feels odd to the IRS, because contractors who have checks normally also have bank accounts. And why are you cashing checks? Well, the IRS jumps to the conclusion, which could be accurate, that you're doing it so you can pay people in cash. And that's one way that the IRS has identified a number of contractors to audit or even potentially prosecute. So the IRS may have information that you don't know about, number one. They have other ways of getting information. But number two, a thorough IRS auditor is probably going to figure this out. So generally, the best practice is to get out ahead of it, to go in and say, you know what, there are problems. Start using the passive voice, that mistakes were made, as opposed to identifying your client as the one who made them. And try to get out ahead of it. Put basically a bow on top of it. Get a CPA, forensic CPA, to basically do the work. Go in and say, well, we found some errors, and for the year that's at issue here, here are the computations. Some attorneys even say, and I've gone back a year because I know that's exactly what you're going to do, or 2 years. And we've already done that for you as well. And we've already amended those tax returns for the years that you haven't yet picked up, but would if you figured out what was going on. Most revenue agents will just say, I'm going to walk away. Thank you so much. You've made my job so easy. We've had some criminal cases where even if the lawyer was trying to do that, the client may not have provided all of the information up front. The lawyer rushes in, for example, trying to get in before the agent puts too much time in. So there's a good reason to rush in. But unfortunately, the information that they give is incomplete. The IRS agent then figures something out. It's missing. Oh, you said you were fixing the problem and you didn't. And they use that as a reason to send it up to IRS CI, which in this instance, the IRS has changed its approach to what cases are important criminally as a consequence of the new administration. Anything that you can say is tied to immigration is something that will get kudos, and it will be considered as something that should be at the front of the line for charging. So if you have a regular employment tax case with no immigration in it, and you have an identical employment tax case that also has an immigration angle, which one do you think is going to be charged at this point? Well, it's going to be the second one. The IRS has been told to start working even more closely with Homeland Security. So those are the cases that will be worked. Homeland Security and IRS, they don't necessarily do a lot of cases historically together, other than on these task forces. But one thing that Homeland Security will learn, just like the FBI has learned, is that the IRS has perhaps the best financial investigators in the government. So if they're investigating an immigration crime, whether it be harboring or transporting folks into the US, it's going to be more likely you're going to see the IRS involved in those cases as well, because they add something. As a prosecutor, it was often easy to get a tax charge where perhaps the bigger crime or the initial reason that an individual is under investigation was harder. Frequently, if you're paying people in cash, you've often got a second set of books. And the IRS will often know about that, either initially because there's a whistleblower, which is another reason why you shouldn't withhold information from the government. They might be sitting on a whistleblower complaint, or through an audit, or they will come in and do a search warrant or subpoena, grand jury subpoena, or a summons if it's an administrative criminal case. So how are you going to handle a case that does go criminal? Well, this is the flavor of the day. This is a case that the IRS and Homeland Security is going to want to get a big press release on. So you need to be aware of that when you're negotiating. The people who are paying attention may be in Washington, D.C. instead of just the local U.S. Attorney's Office, for example. So they are frequently going to want more out of the case because they're trying, as the professor mentioned earlier, they're trying to send a message to employers. This has obviously been what the current administration has done across. I'm not saying anything that's, I think, controversial. They are trying to get messages out in a variety of ways, and one of which is through criminal prosecutions. So how do you handle a criminal case, a criminal investigation in this area, knowing that it's a priority? Well, keep in mind you're probably representing an individual. Proving that the individual actually knew all of these things were going on is not always the easiest thing in the world. In a civil audit, you don't have to worry about that. But in a criminal case, absolutely you should be focusing on the individual that you're representing as opposed to this collective entity. I will point out, if the government does end up charging the entity criminally, which does happen, particularly in cases like this where you're involving an employer, the government still has to prove that someone knew that they were committing a crime. They don't just add, someone knew this, someone knew that, someone intended this, someone intended that. To get a criminal case to stick against an entity, the government needs to demonstrate, again, beyond a reasonable doubt, that someone acting on behalf of the entity, in essence, held all of the necessary elements. So focus on whoever you represent or whatever you represent, because these cases, as politically charged as they are, you might find that the cases also are not being investigated the same way. We're seeing, obviously, a lot of attrition. Is that going to, both in the U.S. Attorney's offices as well as at the IRS and perhaps Homeland Security? So if those things are happening, it's still a standard criminal case. Just work it the same way. So I know we're coming to an end, and I know, Professor, if you have any closing comments, feel free, and then we can always hear from Philip.
No, I mean, I would just to sum up, say that this Hyundai raid, the investigation and the material that was used were time cards, employment records, and photos and camera. And so that, kind of highlights this was a very, I think, politically charged raid as well. And these were individuals who are on short-term visas, and we're going beyond that. So just another example of kind of the scrutiny of the employer records that are being used in these enforcement operations.
So Philip, oh, okay, looks like Philip's not here. It was nice of him to introduce us. I know that there are additional panels coming up that he would have liked to have mentioned if been able to make it. But regardless, thank you so much to the Beverly Hills Bar Association. Obviously, thank you, Professor. I learned quite a bit from dealing with you.
I learned a lot from you, so thank you.
And we appreciate everyone joining us for this. So thank you very much, and have a good day.